This guy standing next to me, Peter Frankel, defense attorney, former prosecutor. He is the legal mind that we need to break down what is happening in the Luigi Mangione case. He's been studying it. We go to you for everything.
Thank you.
And so we're coming to you tonight.
Yeah.
But first, before we dig into your legal analysis, let's cue up Lisa Evers. She's going to take us through what happened in court.
A tense day here at Manhattan Criminal Court as week 2 of this pretrial hearing for Luigi Mangione gets underway. Both prosecutors and the defense team turning up the heat to try to get critical backpack evidence included and excluded. Now, the 27-year-old accused CEO killer, an Ivy League graduate, was back in court again today, sitting at that defense table in this high-stakes pretrial hearing. He was bent over at times, paying close attention to the many minutes of Altoona police body cam video presented by each side to bolster their main contentions. On the prosecution side, that it should be included what was inside: a gun, a silencer, and other things that they feel are key evidence to getting a conviction. On the defense side, they said that there was a lot of problems with both the search and the fact of him not being read his rights on time. On the witness hot seat most of the day, Altoona Police Department officer Christine Wasser, a 19-year veteran who did the controversial bag search. She testified under oath that she thought there might be an explosive device or bomb in the backpack. That's why she searched it, seeming to help prosecutors. But she also admitted that one of her supervisors told her it was okay to search the bag since Mangione was under arrest for a fake ID, while another clearly told her this is serious and they should get a warrant. Luigi Mangione has pleaded not guilty to murder and other charges, which, if he's found guilty here in state court, could keep him behind bars for the rest of his life. In Lower Manhattan, I'm Lisa Evers for Newsroom Live.
All right, Lisa, thanks. Okay, so Lisa just kind of giving us the rundown. Peter, as you know, Luigi Mangione wasn't in court on Friday. We were actually hoping that this whole thing would be wrapped up last week. Boy, do we have another thing coming.
You sure do.
Because I feel like this feels like the trial before the trial.
That's exactly right. That's exactly what it is. It's a mini trial. And we're on witness number 7, I think, of 25, 27. So the witnesses are going to start to go more quickly. We've been at basically one witness a day for the past couple of days. I've been in the courtroom a lot watching it. And, you know, both sides are really struggling to kind of fit the facts, the testimony, into their respective narrative to try to convince the judge, either from the government standpoint that there was no impropriety or from the defense standpoint that, hey, you got to throw some of this evidence out because Mr. Mangione's 4th and 5th Amendment rights were violated.
Do they normally front load the most important witnesses? I feel like at a trial usually, I mean, you can tell us, but you sketch out a narrative and your witnesses follow the narrative. So it might not be your most important person on day one.
Right.
But it has to fit the story that you're trying to have play out. Is it the same way in this suppression hearing, or is it, are you getting all the good ones first and then we're going to kind of like peter out as we go? So
the first thing is, this is so atypical of what these pretrial hearings usually look like. You usually have 2-3 witnesses, not 25, 27. And yeah, in a situation like this, the prosecution wants to get their best witnesses out as quickly as possible. You know, there's no jury here, it's up to the judge, so you want to make sure you have the judge's attention. You want to make sure that you have the testimony that the judge needs to hear to make the ultimate decision that he has to make. So yeah, that's really what's going on. That's why it's been so slow, because the morning's basically been the prosecution direct testimony, and the afternoons have been the defense on cross-examination.
Got it. Okay, so as you were saying, this is so incredibly atypical. I mean, you know, it strikes me as interesting as somebody who's not an attorney and I don't play one on TV, but like it feels like they're really getting a chance, almost like a comic goes to, not that this is in any way funny, but like almost like a comic or an actor or whatever tries their stuff in different places before they reach the main stage. It feels that way, like they're able to see what storylines or what lines of questioning work and don't work.
Yeah, totally, because all of these questions and answers obviously being taken down by a stenographer, and they're going to be used going forward at a trial, not only the state trial, but don't forget, there's going to be a federal trial as well. So these witnesses are testifying under oath. Part of the defense strategy, and part of what the prosecution is doing as well, is trying to lock the witnesses into answers that then that can be used to craft the questioning later on at the trial. So we're seeing a lot of that, but we're really in to the crux of the case right here, because last week we had the two officers who first had contact with Mr. Mangione at the McDonald's, and today we had this patrolman Wasser who was the one that went through his backpack at McDonald's and found a lot of the really critical evidence that the prosecution wants to use against him. So it's going to be really interesting to see whether or not the court finds that Officer Wasser was correct in going through the knapsack, or whether there was a violation of his Fourth Amendment rights.
Now, we always say that the NYPD is the gold standard, really, of any police department. I'm sure if you live in another city, you might think that your police, but like really, it seems like globally, the NYPD is upheld as the best of the best. This officer that was on the stand today is from Altoona, Pennsylvania, right?
Correct.
So not to say anything against them or their experience, but one may assume that they don't have the level of experience that you would have if this happened in New York, right? So could it be that they didn't know, or they didn't know what questions to ask or what to say or how to do it, or could this just, I mean,
that's 1,000%. You just nailed it, Teresa. It's, what is Altoona, 40, 50,000 people, and you're talking about police officers who have never come across a situation like this before. This was huge news for them, and aside from the fact that this was a kind of unusual fact pattern, you have someone alleged to have committed a crime 250 miles away, wanted for murder, potentially facing a death penalty, and you need to try to handle this the right way to make sure that you're not violating any of his rights, so that you're not compromising the integrity of the prosecutions. Really difficult under these circumstances. So it's for that reason that the defense is really hammering the officers with respect to every step they made. And I believe there was some missteps along the way.
So the big thing is the backpack, right? And I remember hearing a legal expert say last week there was this theory of like arm's reach, like if you can explain this more, but if something is within arm's reach of you, are the police allowed to search that without a warrant?
Well,
and this may have been a little bit more than arm's reach?
The general rule in New York is that to search a closed container, a backpack, a suitcase, something like that, there's a presumption that you need a warrant to do it. Now, there are exceptions. Some of the exceptions are exigent circumstances, and today there was testimony that the officer searched because she thought there was a bomb, potentially.
Right. So what happens if, let's just play that out. What happens if there actually was a bomb in the backpack and they searched it and it didn't detonate, and then you come to do this suppression hearing? Would that be more acceptable than not, because there's a threat of danger?
100%. But you can't just accept her word that she thought that there was a bomb, because during cross-examination, the defense said, well, you thought there may be a bomb. Did you clear the restaurant? I mean, you did a partial search. You didn't search the entire bag until you brought it back to the precinct. They didn't search the bag for 20 some odd minutes from the time that they got there. So does this make sense? Are these the things that you would actually do if you thought that there was a bomb? Would you call a bomb squad? Wouldn't you do some of those things? So essentially what the defense is saying is that she's not credible when she says that she thought there was a bomb, and ultimately it's going to be up to the judge to decide whether or not he believes that there were exigent circumstances and the search was conducted because there was a bomb. There are other exceptions as well, to your point. Was this search incident to a lawful arrest? He was being arrested for giving a fake name and having a fake ID. Did that provide them with a legal basis to search the backpack? Another issue that this judge is going to have to decide. Very complicated. You have to put the facts to the law to try to make a determination as to whether or not his rights were violated.
So that takes us to the Fourth Amendment, whether or not his Fourth Amendment rights were violated. I feel like everybody's got to go back to civics class and go, okay, so 1, 2, 3, 4, now 5, Miranda rights.
Right.
And that was a big thing last week too, right? Because he kept asking for an attorney.
Yeah, that's huge, Teresa, because in New York, the standard is if it's custodial interrogation. Custodial means, are you free to leave? Would a reasonable person, innocent of any crime, believe that they could leave, right? It doesn't mean custodial, you're in handcuffs or you're in a jail cell. And in this particular instance, there were 10, 12 police officers surrounding him. So the defense is making the argument, look, he wasn't in handcuffs, but he was clearly in custody. He wasn't free to leave. right? So you couple that with the fact that he was being questioned repeatedly for a long period of time. 2 + 2 = 4. He was in custody and he was being interrogated. So the defense is saying, look, based on the facts and circumstances, and you have it all on the body-worn camera video of everything that took place at McDonald's, you've got to throw these statements out because it was a violation of his Fifth Amendment rights. He wasn't Mirandized, given his Miranda warnings, until much further along in the process.
So we know that Karen Agnifilo is a top defense attorney, right? So she is doing what she is paid to do. But I do wonder, Mangione is somebody who, from what we understand, comes from means. I don't know if his family is contributing in any way, but we know that he grew up somewhat wealthy. There is a huge GoFundMe or crowdsourcing to help raise money for him. So he's got funds behind him. What is happening in this pretrial suppression hearing, you said it's not typical in terms of length or in terms of breadth, but would any other criminal defendant who maybe didn't have access to someone of Karen's caliber get the same shake at this? I mean, is this one of those things where what happened in the Altoona, Pennsylvania McDonald's and the missteps that may or may not have been made are something that any defense attorney would have picked up on because they're that glaring? Or is this the result of really fine-tuned lawyering?
It's such a great question. Like, you really hit the nail on the head. The short answer is it's the result of top-notch lawyering is really what it is. A lot of lawyers, a lot of clients don't have the resources to put into a defense. If you have a court-appointed lawyer, some of them are excellent, but they also don't always have the resources. So, it's unfortunate, but to your point, when you have essentially unlimited resources, you can do all sorts of things that a normal person who's charged with a crime doesn't get the benefit of doing. And at the end of the day, it makes a huge difference when you get to court.
Yeah, not to put you out of business, but this is why we need the public defenders, right? I mean, this is why you need people who are well trained in order to step up and pay when others can't.
Yeah,
I do wonder if this is a case, and then we'll let you go after this because you got to go eat dinner. But I do wonder, though, if this is a case that ultimately, whatever the outcome is, right, whenever this case is done and they move on to the federal case and whatever ends up happening here, if this is a case that's going to be taught in law school because of the issues with the Fourth and Fifth Amendment rights, the chain of custody, and all of the different things that have gone on.
Yeah, I mean, this case has everything. It's got, so much to unpack, and what's also unusual about it is that I don't know if you've been down to the courtroom in the courthouse, but Mr. Mangione has an incredible following of people,
it's impressive,
who are not only contributing to his defense fund, but who are also in the courthouse, in court, outside, every day, supporting him. So, this is one of those sensational cases that, you don't see, every day.
Yeah.
It's got so much going on.
But admittedly, we are seeing them more. Like we saw it with Ghislaine Maxwell. There was a line of people every day to go see that case.
We saw it with Diddy also.
We saw it with Diddy. Even Weinstein, we saw it with Danny Matheson. I mean, there have been cases. It seems like this is now the norm. Not the norm, but because there's nothing normal about this. But it seems like people, especially with the rise of true crime on TikTok and all of that many more people are willing to take a day, waste a day, do whatever.
Yeah. And not to get too much in the weeds, but you've got people that are supporting him because of their hatred for the healthcare system. Right. Meanwhile, if it ends up that he's convicted, I'm not sure that that's the hill that you want to die on, and that's the way that you want to support whatever your grievances are with the healthcare system. So we shall see.
Peter, thank you so much.
It's my pleasure.
I appreciate you spending your dinner time with us and all your
pleasure.
legal analysis. This is not going to end anytime soon, so we're going to be calling on you.